Hey y'all! To start off our series on voter suppression in Texas, we are going to take a look at the Voting Rights Act of 1965. And we're also going to look at the Supreme Court's decision to overturn a key provision of that act in 2013. So if you're interested in the impact of this ruling on American democracy and how it affects your rights today, especially in Texas, stay tuned. In 2013, the Supreme Court made a historic decision to strike down Section 4 of the Voting Rights Act. Let's break down what this means and why it matters. To understand the impact, let's first look at Section 4 of the Voting Rights Act. Enacted in 1965 during the height of the Civil Rights Movement, the Voting Rights Act was designed to address racial discrimination in voting, particularly in southern states where there were significant barriers preventing Black citizens from voting. In 1965, most southern states had provisions that essentially prevented Blacks from participating in the political process or made it incredibly difficult for them to vote. Barriers to voting were absurd. Almost all southern states instituted poll taxes, and some areas even made Blacks guess the number of marbles in a bottle before they could vote. The Voting Rights Act was built to remove these barriers and prevent new ones from being enacted in states with a history of voter suppression. So to break it down a little bit more, Section 4 of the Voting Rights Act is a formula, and that formula determines what states will be covered by Section 5. The formula in Section 4 was based on the percentage of Blacks who were registered to vote in 1965. So if less than 50% of the Blacks of voting age were registered to vote, or if less than 50% of Blacks of voting age voted in 1964, then Section 5 applied to that state. And Section 5 of the Voting Rights Act is a provision that neither states nor subdivisions of the state could make any change in election process without first getting the permission of the federal government. So those areas had to demonstrate to the federal government that any changes they were trying to make to the election process would not have the effect of discriminating on the basis of race. In 1965, it was on the basis of race, and that was extended later on, which we'll see in a second. So essentially, Sections 4 and 5 of the Voting Rights Act made it so that if a state had a history of discriminatory practices, it had to get permission from the federal government before making changes to its voting laws or practices. This was known as preclearance. So in 1965, when the Voting Rights Act was initially passed, Texas was not covered by the Voting Rights Act. We'll have a separate video going into why that is. There's a lot of theories about that. But for now, let's focus on subsequent extensions of the Voting Rights Act. So with the exception of Trump, all Republican presidents have signed extensions to the Voting Rights Act, and in each case, the Voting Rights Act was passed with broad bipartisan congressional support. It started in 1965 with Lyndon B. Johnson, and then it was extended in 1970 with President Nixon. In 1975, Gerald Ford signed the extension, and this time it included Texas. In 1975, when Texas was covered by the Voting Rights Act, within 364 days, Texas had more objections than any of the other states who had been covered already for 10 years. Let's take a closer look at that first year Texas was covered by the Voting Rights Act. So in 1975, the Voting Rights Act was extended for an additional 10 years. It underwent significant amendments. And during this extension, Congress decided to add Texas to the list of covered jurisdictions. This decision was driven by evidence that Texas had persistent voting discrimination issues similar to those in covered areas. The extension also introduced provisions to address language barriers, requiring translation of election materials into languages spoken by significant portions of the population. Language was a huge part of the extension of the Voting Rights Act and having Texas and Hispanics to be covered by the Voting Rights Act. The inclusion of Texas in the special provisions of the Voting Rights Act was a part of a broader effort to ensure that all voters, regardless of race or ethnic origin, had equal access to electoral processes. And for a while, it worked. The first voting rights objection in Texas came that same year in 1975. The state legislature of Texas had passed a statute that got rid of all persons registered to vote. They purged all the voter registrations and required that every single person had to re-register to vote, otherwise they wouldn't be able to vote. The people who did this claimed that they were doing it because voter rolls had gotten so confusing. This was before computers, and there were 5 million people registered to vote. So there are stories of offices being full to the brim of hundreds of thousands of voter registrations. However, it was demonstrated that by purging all voter registrations and requiring that everyone had to re-register to vote, voices of primarily low-income and minority voters were suppressed. And because Texas was by that time covered by Section 4 and 5 of the Voting Rights Act, Texas was unable to get federal approval for the purge, and so the purge thankfully did not happen. So if we hadn't have been covered by Section 4 and 5 of the Voting Rights Act, then in 1975, every single person who was registered to vote in Texas would have had to re-register, otherwise they would not be able to vote. So that's just the first thing that happened. From 1975 to 2013, the Voting Rights Act continued to be extended and did so much important work ensuring that oppressive voting policies did not come into effect in Texas. For example, in 2005 and 2007, Republicans tried to pass voter ID statutes in Texas. Voter ID is a huge issue. If you haven't heard much about this, we're going to have a whole video focused on voter ID. But essentially, because Texas was covered by Section 5 of the Voting Rights Act, civil rights attorneys were able to keep voter ID statutes off of the floor almost entirely. The only time it came to the floor was because
a Democratic state senator
named Gallegos had to be wheeled out on a hospital gurney to vote, and there's a lot of drama and tea that surrounds that, which we will also make a whole video talking about that day. All this work making sure that voter suppression policies did not come into effect in Texas happened under the Voting Rights Act. Civil rights attorneys had a lot of capacity to protect voters from any suppressive efforts. In contrast, within 1 hour after Section 4 of the Voting Rights Act was overturned and invalidated by the Supreme Court, Texas began enforcing those same voter ID laws which the people of Texas had been protected against since 1975. So all of that work, within an hour of overturning Section 4 of the Voting Rights Act, it was completely null. The Supreme Court ruled in the case of Shelby County versus Holder that Section 4 was unconstitutional. The court argued that the formula used to determine which areas required preclearance was outdated and no longer reflected current conditions, citing essentially common knowledge that the status of minorities had improved. The court's majority opinion, written by Chief Justice John Roberts, argued that the formula was based on decades-old data and did not account for the progress made since the act was originally passed. The decision effectively eliminated the preclearance requirement, shifting the responsibility of monitoring voting changes back to the states. I'm just going to do a quick little reminder here that courts in the United States are not supposed to make law. We have 3 branches of government. Courts are supposed to determine whether or not laws are fair. With this decision, the Supreme Court invalidated action by Congress. The extension of the Voting Rights Act was passed in the Senate 98-0. I'm going to say that again. The extension of the Voting Rights Act was passed in the Senate in the 2000s, 98-0. No one voted against it. And it passed in the House, losing only 16 votes. There were thousands of pages of testimony and exhibits that Congress had when they passed the extension of the Voting Rights Act. It was an enormous record of evidence demonstrating the importance of the Voting Rights Act. There has never been a Supreme Court case where the passage of an act was so overwhelming by Congress, and yet the Supreme Court revised it. This is arguably making law, and thus outside of a court's capacity. The only justification that the court used to overturn a unanimous decision by Congress was essentially that everyone knows that things are different now than they were in 1965. If everyone knew, then wouldn't Congress have known too? Shelby v. Holder has been argued as perhaps the worst decision ever by the Supreme Court. And our current Supreme Court is given a run for its money, but this is still one of the worst decisions, if not the worst decision, by the Supreme Court. In practical application, when Section 4 was invalidated, Section 5 remained, but is now completely ineffective. You can't use it because the equation that it's based on, there's no protection left. So even if you win a Section 2 lawsuit, so in Section 2 of the Voting Rights Act, the burden is on the plaintiffs to prove that the election change is intentionally racially or ethnically discriminatory. Because of the time it takes to try a federal case, these changes are often still in effect for at least the next election cycle, whereas when Section 4 was in effect, you couldn't have any voting policy put into place without first getting approval that it was not discriminatory. So we're having a rise in voter suppression because it takes so long with the courts to make sure that the policies that are in play are not oppressive. Since the Shelby County decision and overturning of Section 4 of the Voting Rights Act, there have been numerous reports and concerns about voting rights, not just in Texas, but across the country. Within 24 hours, voter ID laws were passed in Texas, which, as we discussed before, were repeatedly invalidated since 1975. That was within 24 hours. Several states have passed new voting laws, some of which critics argue disproportionately affect minority communities. For instance, there have been concerns about changes to early voting, closure of polling places, and so many more. This ruling has sparked an ongoing debate about the balance between state and federal powers and the protection of voting rights. While the Supreme Court's decision aimed to address outdated provisions, many argue that it has opened the door for voter suppression. So, what's next? The discussion around voting rights is far from over. There are ongoing legislative efforts and court cases addressing voting access and election integrity. The debate continues about how to protect every citizen's right to vote while also respecting state sovereignty. It is clear that the formula that was put together in 1964 is out of date, but it is also clear that there is precedent to expand voting rights based on new qualifications like language. In 1965, it was thought with the Voting Rights Act in effect, within 10 years, blacks could equally vote. They thought by 1975, this issue would be solved, everyone would be equally allowed to vote. But now, over 50 years later, we are trying to extend the Voting Rights Act again because states are still fighting so hard against it and are finding new ways to suppress minority votes. When the Supreme Court overturned Section 4 of the Voting Rights Act, in practice, what it meant was that an onslaught of voter suppression tactics suddenly came into effect with essentially no oversight. In the rest of this series on voter suppression, we are going to take a closer look at each of these tactics and how they affect voters in Texas. It is crucial for all of us to stay informed and engaged on these discussions. Understanding the implications of such rulings helps us advocate for fair and equitable voting practices. Thanks for watching. If you found this video informative, please don't forget to like, subscribe, and hit the notification bell for more updates on important issues. Drop your thoughts or questions in the comments below. Let's keep this conversation going. And I'll see you in the next video in our voter suppression series where we talk about voter ID laws.